Welcome back to the Inland Empire Workers' Compensation Lawyer live stream podcast. My name is Attorney Alexander Napolin. I'm here with Attorney George Abuado. We're your hosts every Sunday at 3 o'clock on this channel for a new discussion on workers' compensation and employment rights in California. This is episode number 9 on how to achieve a lump sum settlement in a workers' compensation case. So if you've been injured at work or you're a worker and you become injured, you probably will be wondering, am I going to get a lump sum settlement for this workers' compensation case? So that's what we're discussing in episode number 9. If you work in California, you should subscribe to our channel and hit the notification bell so you don't miss out on these important weekly discussions that will help you and help you protect your legal rights. So how do you actually achieve a lump sum? You need to have a compromise and release, which is something that the insurance company and you have to negotiate. There's no judge that can award you this lump sum in a workers' compensation claim, right? You have to have an agreement with the defendant. Yeah. So in a way, you have to have sophistication on your side, bargaining for you, knowing how to navigate the system to make sure that you max out all of your benefits from now until forever. Once you're at that point, you have a lawyer, then the insurance carrier may approach your lawyer or your lawyer may approach the insurance company. There can be an agreement on how much the case can be settled for in terms of lump sum.
Correct.
Versus the other way, which is just nothing happens with the claim and maybe you get care in the future and maybe you don't.
One important thing to note about a compromise and release is that no one is forced into a compromise and release. If the insurance company, through the defense attorney or through an adjuster, offers you a settlement amount, that's what they're offering you. If they don't want to offer any money, they don't have to offer any money. The court cannot make them offer you a compromise and release. It cannot be forced upon any party. That's one very good thing to note.
Yes.
Another thing to note about a compromise and release is that you're closing out your claim completely. After you close out your compromise and release, there will be no issues left in your claim. You can no longer go back to the insurance company and say, hey, I want more treatment. You can no longer go back to the insurance company and say, hey, there were some issues with my wages. They need to be computed correctly because they were computed incorrectly. There's many issues and they're all closed out. Once you sign a compromise and release, whether you have an attorney or not, that claim is completely closed. It's something very important to note, Alex.
That's true. Once it's signed and a judge has approved it.
Correct.
Because the judge still has to approve the compromise and release. So if the insurance adjuster has had you sign some compromise and release, you could probably still try to show up to whatever court you think they're going to.
Correct.
Call a lawyer immediately.
Definitely.
If you think that you settled your claim for too low and your insurance adjuster is giving you this compromise and release thing, this is general information that's meant to help you. It's not legal advice. For legal advice, you need to call Attorney George Abuado, Attorney Alexander Napolin. The injury hotline is 844-984-8414. That reaches the Inland Empire Workers' Compensation Lawyer live stream podcast injury hotline. You can also direct message us on social media or reach out to us directly on our profiles if you have questions. Now, remember, as we discussed in prior episodes about social media, the insurance company looks at your social media. So if you're wanting to get in contact with us about a specific issue, something that you think is sensitive, don't post it. You need to contact us directly.
Correct. A lot of times when I am closing out a claim for my client, the defense tries to put in a addendum in there that it has to do with you not working at your job anymore, you giving up the right to work where you used to work. Now, there's two ways to go about this. It could be either a resignation letter where you say, I, so-and-so, resign from my position. I no longer work there. I will no longer ever apply to work for them or any of their subsidiaries, and that's so you giving away your rights to work for them. Now, this is very important, especially for a company like we discussed, like Amazon, because they have many subsidiaries that you might not even know about that they will preclude you from working with them if you do sign this compromise and release. We'll go ahead and put that to the side. We already discussed that in one of our other videos on Amazon. Please go check that one out. But that could be a big issue. Now, another thing that could happen if you sign a resignation letter is it could negate or greatly reduce your rights to an employment law claim for wages, for wrongful termination, for discrimination, for harassment. If you resign and they have a letter of resignation, it could limit your claims that you might have under employment law. Your attorney will know whether or not you should sign that resignation, and they'll give you the proper legal advice at the time.
Right. So like, for example, if it really doesn't matter at all because there are no violations and you're separating your employment anyways, and they ask you to sign a resignation and they're being extremely and the insurance adjuster is being extremely stubborn about it, I might tell my client, go ahead and sign it. We're not going to go around on another 2-week negotiation.
Right.
Yeah, we'll win the battle, but let's get the CNR granted. Let's get the lump sum paid. Let's get the lump sum settlement granted by the judge. Let's just sign the resignation. Like that might be a situation.
Correct.
But if there's real rights at play, the adjuster shouldn't be negotiating those other rights away with the lump sum settlement from the workers' compensation claim.
Exactly.
Although obtaining the resignation might be worth something in the whole mix.
Right. And that I did want to point out that this is an issue that is behind the scenes, and some attorneys might not know about it, and definitely I think the client wouldn't know. Sometimes, very rarely, you are able to negotiate a compromise and release without a resignation, without a separation from employment. Why? Why are some cases different than others? Well, if an insurance company covered your past employer to a certain amount of time and they're the ones dealing with your claim, but now your employer has a different insurance company who is taking care of their new claims, well, the old insurance company is no longer technically involved with your employer. So technically they're what's called off the risk. So now you can negotiate with them, do a compromise and release, and if your new employer has a new insurance company, they might not care whether you sign a resignation or a termination of employment or separation from employment. They'll let you sign that compromise and release, get the lump sum money, and still go back to your job. Very rarely does that happen, but it can happen. I've seen very sad situations been involved in where I have a potential client that comes to see me and says, I'm injured, I was hurt at work, and I'm not getting medical treatment. I want medical treatment. And I say, of course, let me come in. We'll talk about your situation. And sure enough, they've been very, very badly injured and they want to get medical treatment. But then they pull out a signed CNR from 6 months ago, from a year ago. And they don't understand that they've closed out all the rights. I've seen this a lot. And unfortunately, what I have to tell them is you can always seek a second opinion. My opinion is not the final opinion. I have to say that because I want to protect myself. But we won't be able to take your case because, in my opinion, you signed a compromise and release. It's been signed by a judge. There's been an order given. Therefore, your rights are done. Your claim is completely done. And a lot of people don't understand this, and I've had to turn a lot of people away, and it's sad. And I think that they weren't explained their rights when they had to sign. You want to find the right attorney, one that's going to explain everything to you. So when you leave and you sign away your rights, you know exactly what you're doing.
Clients come to you. They say, okay, I signed this paper. What happens after that?
After the documents are signed, the settlement documents are signed, those go back to the defense attorney. He has to review them again and then sign them again. Well, sign them. And then what he does is he prepares them for a walkthrough to go in front of the judge in order to get the order approving. The judge will do a full and complete review of the settlement, make sure that there's no discrepancies, make sure that everything is correct on the settlement. Once the judge signs it, on that day that he signs it, the insurance company has 30 days to pay you what was on that settlement. If they don't, there could be penalties, there could be interest tacked on, and we could talk about that in another one.
Yeah, a lot of complex issues.
Yeah.
A lot of things that go into a claim that doesn't settle by lump sum. A lot of things you have to do to achieve a lump sum settlement. Mm-hmm. And I think that is what you should have picked up from this discussion today. That's it for today. Join us next week, Sunday at 3 p.m. for another live discussion about workers' compensation law and employment rights. Next week, we will be discussing the time limit that you have as an injured worker to file a workers' compensation case at the workers' compensation court after you're hurt at work.